Now, I'm not here to talk much about what mediation will help the corporates. My focus is need of institutional mediation. Now, before that, I'll try to address what is institutional mediation. You approach a person individually and ask for mediation. There could be some mishaps. There could be documentation issues. There could be streamlining issue as a problem. These are issues which we majorly see when you approach an individual. Institutional mediation is they help the process to run as per the mandate. They suggest the mediator as to what could have been done better, what issues have been missed by oversight or for any other reason, and how things can be improved. This is the focus when an institution enters into mediation. Meaning to say, Dispute Resolution Hub helps you to act as a bridge between mediation process and what is expected by the litigant in solving the issue. How do we do it? We have a process which is similar to a courtroom, which records the entire proceedings of mediation, and we help you by something called a secretarial service. Means someone says, I know this is the dispute, I'm not able to put it in words, I know what is the amount I'm supposed to get, I have my advocate, but I want a second opinion on it. This second opinion is something called a secretarial service, where we'll explore the entire claim which is made before us. We will see what are the issues, what are the prayers made. We will also suggest, it's not a prayer there, it is a conflict which is there. We will suggest that this conflict, these aspects are covered, these are not covered, so we can list them as issues while discussion. Now during discussion there is a recording and there is a next date given. During today's mediation discussion, we will estimate and evaluate that these issues are solved or negotiated. These are the issues which are pending. We will prioritize the rest of the issues and see that the process of per issue being discussed by the parties is recorded, documented, and confidentially held by the Institutional Mediation Center. By this, parties know what has happened. Issues will not become redundant and repetitive. Effective mediation is implemented. Now there is a summary given at the end of each mediation proceeding that has happened. Now this summary will tell you whether the mediation is sailing or it is collapsing. If it is collapsing, you can bring it out faster. If it is sailing well, you can as such see what are the next stages that are coming up. So each mediation sitting will have a mediator, parties, recordings happening simultaneously. Now there would be some evaluation here. In between the entire mediation process, I feel as a litigating party that mediator has become one-sided. It is human, we'll feel. First we'll try to evaluate how strong is the feeling and how factual is the feeling. If the feeling is strong and factual, we have a system of changing the mediator. Now this is not done abrupt. This is done in due discussion with the current mediator, with the upcoming proposed mediator, or we will say let's not have a single mediator, we'll have 2 or 3 mediators added, and then we'll solve the entire process. So there is nothing called abrupt. As we said, mediation being a facilitation to see that parties resolve the dispute, we try to take all these precautions. Now there could be another type of issue that crops up. The mediator which is mediating our concern is not subject equipped. I am into hotel industry. Mediator does not have hotel knowledge. But technically mediator understands that to settle the issue or to negotiate the issue, you need negotiation skills, not hotel industry expertise. Right? But the hotel industry experts, they feel no, it's not happening. So we try to add another mediator who has a hotel expertise, who can suggest the process and see that the process gets concluded faster. For mediation facilitation, what is required is a negotiation skill, presentation skill. And generally, whenever people come out with a conflict, they try to come to the courts, they try to come to the mediator or arbitrator. This is the first time where the parties are allowed to present the case in mediation. And you are not talking to the other party, you are actually talking to the mediator. Imagine what happens. You vent out your anger on the mediator, not on the party, because party is on the other side. So the biggest challenge mediator has is to absorb that vent out anger. Have cool and presence of mind. That is where training comes into play. Then identify where the real issue lies. They list it out and then say, in today's 2.5 hours of discussion, 2 minutes is relevant. That 2 minutes is on this issue. This is where you are there. This is where you are there. This is the loss to both of you. This is the profit to both of you. If this is presented, then the mediation process is concluded. This is where our dispute resolution hub comes into play. We see that this process is executed stage-wise in a systematic and a documented, recorded way. Now the second question which any person who comes to us and says, I want to go for mediation, I am giving you so much of information. The feeling is, they give us certified copies of their property. The feeling which they have is, they are lifting their house and keeping in our place. This is the difference. So what is asked is protection of those documents first. Second, what is asked is guarantee that these documents will not be misused. Mediation, whatever is given, it is not an evidence, it is an information. Information can never go against you, evidence can go against you. So this information, the purpose of that information being collected is to comprehensively understand the issue. It is not to fix you. And this evidence is always stored upon your request. When you withdraw, the documents and the request is also given back to you. But this proceeding, whenever we have something called a pre-litigation of cases, so whenever there is a PLC called for, the judge would ask what happened in pre-litigation. In a general scenario of panchayat discussion, there will be one small paper which says so and so conducted the issue, so and so parties attended, so and so were witnesses, result is nothing happened. There is no description also here. Now in our case, we will give you a complete proceeding and say there were 10 hearings that have happened. In this 10 hearings, this was the summary of the hearings. The total proceeding was successful or a failure. This is the discussion. So the judge tomorrow knows, if it goes into litigation, what are the areas of concentration they have to work out. Our focus is to decrease the burden on the judiciary. The reason being, the number of cases that are filed, the number of cases for which judges are given time to, and the number of cases for which expedition is happening is much, much lesser than the number of cases that are filed. We try to expedite and solve 10 cases, 10,000 cases are filed. When will the process happen? And if there is an order is coming, as a rule, we don't like the order. One of the person don't like the order. And if it is a check bounce case, both the parties don't like the order. That is a beauty. The person who has got the or complainant gets the check bounce case in their favor, there is a conviction. Person who has, the complainant who has won the case goes to the court and says, I am not happy with the judgment. The judge should have given him 6 months of punishment. The judge should give thrice the amount of check. Judge did not do it right, hence I am appealing. Person who is convicted anyhow will appeal because he needs bail. So his appeal is judge did not appreciate my evidence. So and so, blah, blah, blah happened. And finally that appeal also goes. These two run parallelly. They go again, and it continues. A simple check bounce case, we have seen cases where there is no evidence that the person gave money, but still they fight for about 5 years. In 5 years, there is some judgment, and the judgment is appealed, further appealed. And finally, they are in the courts. If this comes to mediation, that's the reason now it is a summary trial case, where every check bounce you go try in for mediation first. If it is a genuine thing, you have money, when you have paid something, where is your focus? Principal or interest or both? Guess. Genuinely it is principal first. First my money should come. If possible, interest. If my fortune is great, damages. If my fortune is extraordinary, I'll get something which I'll not imagine. But what is genuinely asked is principle, and many people don't find this fact that no check bounce case gives you money. Fear of conviction leads to settlement. But if the person is convinced on conviction, it's over. It's only appeals that run. You will not get your money. Now this point, if it is driven, then the commercial disputes will not knock the doors of the court. For two reasons. When you have systematically understood your issue, the conflict gets collapsed, egos get subsided, reality check is given, relationship continues. This is the focus when we say an institutional mediation enters. And if you have a doubt in the person who is mediating, you can ask, we will facilitate and see that this person who is trying to mediate does it more effectively. And when there is a record as to what conversations were there, how the conversations led, whether the conversations were actually driven in the form of mediation, because we have a record, we can tell you that this has been done right, this where it has went wrong, now we'll try to rectify in the next hearing. This facility is what we are trying to give to the chambers also. So we'll work together with the chamber to see that things move forward well and positive for you. Thank you for listening.